Today, we're diving into a situation that is pretty much every job seeker's worst nightmare. You did it, you got the job offer, you're excited, you're probably already making plans, and then, boom, the offer gets pulled. It feels totally wrong, but is it actually illegal? Okay, let's get into this really tricky legal gray area.
So just picture this for a second. You get that formal offer letter, awesome, but you've got a couple of perfectly normal questions about the contract. So you send an email, and the very next thing you know, the company has just rescinded the offer. It's gone. What now? Is there anything you can do? I mean, it feels like a situation where you should have some kind of protection, right? But as we're about to see, the legal reality can be, well, pretty different. We're going to break down two recent Australian court cases that really shine a light on what your rights actually are before you've worked your first day. And the answer might surprise you. Now, to really understand these cases, we first need to get our heads around a key idea in Australian workplace law. A lot of us think we're protected by this kind of workplace right shield, especially from something called adverse action. So, what is adverse action? Well, under the Fair Work Act, it's basically when an employer does something negative to you, like firing you or, pulling a job offer for a legally protected reason. And one of the biggest protected reasons is exercising a workplace right, like making a complaint or even just asking a question about your job. And this, right here, this is the absolute heart of the matter. The courts have drawn a super sharp line between a prospective employee, that's you, with an offer but you haven't started yet, and an employee. As we're going to see, your legal protections are worlds apart depending on which side of that line you're on. All right, let's jump into our first case study and see how this actually plays out in the real world. Let me introduce you to Stephen Late. He was a meat inspector, had been for 20 years. His job was being made redundant, but he got an offer from the new company that was taking over. Looked like a pretty smooth transition. But check out this timeline. You can see just how fast things fell apart. In February 2023, Mr. Late gets the offer. His union, doing its job, just makes some standard inquiries about the contract. The company replies, but then in March, they pull the offer completely, just 1 week before his old job officially ended. Ouch. And here it is. This is the key line from the company's email, and it became the core of their whole legal argument. They said, point blank, he was not considered an employee. Their argument was simple. Because he hadn't started work, he just wasn't protected yet. Now, our second case really hammers home the same legal point, but honestly, it's from a perspective that feels even more sensitive. This story is about a man named James Heaney and a job offer from the National Disability Insurance Agency, the NDIA. The sequence of events here is it's brutal. So Mr. Heines gets a formal offer. The hiring manager at the NDIA actually advises him to resign from his current job, which he does. He then does exactly what you're supposed to do. He lets them know about his disability so they can get the right workplace adjustments sorted. And then, shortly after that, the NDIA pulls the offer. The stakes here are just massive. He's now completely out of a job. So, okay, we have two different people, two different situations, but both had their job offers yanked away right after they brought up some questions or personal needs. It seems like a pretty clear-cut case of adverse action, right? You'd think so. But in both cases, the courts dismissed their claims. Let's dig into exactly why. So here's how it all broke down in court. The people who lost their offers argued that their questions were a protected complaint and that they had rights as prospective employees, but the court saw it differently. It decided their questions were just inquiries, not formal complaints. And this is the big one. It ruled that any workplace right has to be anchored to a real legal document, like a signed active contract. Without that anchor, the protections just aren't there yet. So let's talk about that first finding. This distinction is so important. The court basically said that just asking for more information about a contact isn't legally the same as making a complaint, which in their eyes means you're expressing some kind of unhappiness or discontent. It's a very fine legal line, but it turned out to be a really important one. And that brings us to the second key finding. For a workplace right to actually exist, it has to come from a real concrete source, like a law, an industry award, or an active employment contract. You can't just have a right that's kind of floating around out there. It has to be tied to a formal legal document. And that leads us to the final knockout punch. For both Mr. Late and Mr. Heines, at the exact moment their offers were withdrawn, there was no active employment contract. The deal wasn't done yet. So that legal source for their workplace right, it simply didn't exist. The protection hadn't picked in. Okay.
So after all that legal deep dive, what does this all actually mean for you if you're excited about a new job offer? What are the big takeaways from all this?
Let's put it plain and simple. A job offer is not a guarantee until you start. As a prospective employee, your legal shield is, well, a lot smaller. Asking questions about your contract might not be legally protected in the way you hope, because what these courts have said is that the real employment relationship and all the powerful protections that come with it doesn't legally begin until day one on the job.
And that really leaves us with a pretty tough final thought, doesn't it? These cases expose a huge gap between when we feel like we're an employee and when the law says we actually are. It really makes you wonder, if your rights don't truly kick in until day one, how safe is any job offer really? Definitely something to think about.